What's up, everyone? This is Christian Duke from StrengthAddicts.com. Want to talk a little bit about 1,3-dimethylamyline, otherwise known as DMAA, and a video that I just saw from Marc Lobliner from Tiger Fitness. First of all, I appreciate Marc reading the case, weighing in. You know, as someone that's been through lawsuits, I'm sure it's not been pleasant for him, and I know that he made the video with the best of intentions. That having been said, I'd like to weigh in myself. And first of all, I'd like to say one thing for the record. In the federal court system, you got district court, court of appeals, U.S. Supreme Court. District court is the lowest court. Okay, so when district court issues a ruling, it really isn't the kind of precedent that Marc is putting out there, okay? And especially when the ruling is on a motion for summary judgment, which basically means that there's no general dispute as to material fact in the case. That's a pretty big call right there. That's very, very appealable. So I would imagine that the company would appeal and that question would go to the next highest court. Now, if that question goes to the U.S. Court of Appeals, and the U.S. Court of Appeals finds that there is a question of material fact, which, by the way, that's a pretty low standard. I mean, that's just saying that there is an unresolved matter. If the Court of Appeals finds that to be the case, and the Court of Appeals sends that case back to the district court, or I should say back down to the district court, and tells them, you have to let this case proceed, in which case DMAA is not illegal until that case is decided. Now, the whole idea of, small amounts, I personally find very troubling. The fact that this judge, is going to interpret what Congress intended, that's called legislative intent, I think is pretty ballsy. You know what I mean? It almost might even, smell a little bit of judicial activism, which is where, you're making law from the bench. Okay. We're talking here about small amounts found in plant and the case of yohimbine, and how, well, there's more in yohimbine than there is in, the plants that produce DMAA. Well, we can also look at, caffeine. Now, caffeine here, it says there's 1.1% to 1.4% caffeine per coffee bean. Okay, that's 1%. But then we could look at something like broccoli. Chromium picolinate is a very, very popular trace supplement that is sold by every company imaginable for years. Now, I looked up a stat here. It says for every half cup of broccoli, there is 11 micrograms of chromium. And many supplements in the fitness industry have 1,000 micrograms of chromium. So I would say that chromium is not abundantly found in broccoli, but yet somehow it's being sold and that's okay. So if it's okay for chromium, why isn't it okay for DMAA? But then someone might say, like in the case, well, just because it's found in the plant, if it's not used directly from the plant, then, it may not pass muster. Well, sugar. Let's talk about sugar. Okay, the product that kept stevia off the shelves as being a sweetener for years, that powerful sugar lobby. Okay, now sugar has to be cut. The sugar juice, it has to be cut. Then the stems have to be flattened. Then the sugar juice is collected. It's filtered, it's treated, and then it's boiled to drive off excess water. Now, that's a lot of steps that have to go so that you can get sugar from that cane into your coffee in the morning, into your baked goods, and into your delicious candy bars that will cause obesity and diabetes in many Americans. Now, it's interesting because that sure doesn't seem to me to be a direct extract from the plant. That seems to be like a lot of different steps. So I guess my main issue here is that before we run and dump our supplements, before we, say, well, it's illegal, precedent has been set, we must now all adhere to this mighty ruling from this low-ass court, I think we should maybe hope that, you know, this bizarre decision to grant the government summary judgment be appealed and be re-examined by a higher court based simply on that question. That very procedural, highly technical, highly debatable decision by a district court that may very well be engaging in judicial activism and not know its head from his ass as far as what Congress truly intended. Thanks for watching.